Good morning. My name is Anita Saxby, and I'm part of FISRA's communications team. Thank you for joining us this morning. We're excited to talk to you today about FISRA's supervisory approach to DB asset transfers under the PBA. We're about to get started, but I wanted to first go over some housekeeping items. We're using Microsoft Teams Live platform today for our webinar. That means that your microphone will automatically be off, and your video will also be off. So all you need to do is listen, watch, and enjoy. We welcome your questions. You can interact with us and ask your questions using the Q&A button on the top right of your screen. We will address questions at the end of our presentation. This webinar will be recorded, and FISRA will share a link to this video in our next Pensions Update eBlast communication. If you have any connectivity issues during the webinar, please try exiting the webinar and joining again with a fresh connection. And now I'd like to turn it over to our presenters today. I'd like to introduce you to Mark Eagles, Director, Advisory Services, and Tim Thompson, Senior Manager, Special Transactions. Mark, over to you to kick things off.
Thank you, Anita. And good morning, everyone. First of all, I just want to thank everyone for joining us for the next hour. Being the pension dweeb that I am, I'm really amazed to see that we have so many people signed up. I think we have over 270 people signed up for this webinar, which is excellent. Also, I would like to thank all of the FISRA pension and legal staff who have worked so hard over the last year and a half to get us to where we are with this asset transfer guidance and our new approach to reviewing asset transfers. Also, I'd like to thank our IT team and our FISRA communications team who have made this event possible. We're using this Microsoft Teams live event for the first time today, so this is something new for us. And I think a year ago we didn't really even have a technology to do this. I certainly didn't. I didn't even have a laptop computer to allow me to work at home. So I guess that's one of the sort of small silver linings of our COVID-19 pandemic. Speaking of technology, our IT team will be happy to hear that I was unable to locate a cat filter. Maybe next time. Also, I'd like to give many thanks to the members of our Asset Transfer Technical Advisory Committee that met with us over a period of about 9 months or so, and who gave us dozens of hours of their free time and their invaluable input, feedback, and advice. Finally, a personal thank you to Caroline Blouin. She's our EVP of Pensions at FISRA, and it was her unwavering support that allowed us to totally rethink our asset transfer process and to get this guidance published. So, as you may have gathered, our webinar is focused on defined benefit asset transfers under Section 80, 81, and 80.4. And Tim and I will take turns speaking for the first 50 minutes or so on these topics, and then we'll have about 10 minutes, at least 10 minutes of time to answer your questions at the end. You can submit written questions only, but at any time during the webinar, and there's a button, I think, in the top right where you can do that. If we have extra questions that we haven't been able to answer at 12 o'clock, Tim and I will stick around for a few extra minutes. We can try to answer some more. The only request I have is that you do not ask plan-specific questions. We would be happy to discuss those with you at a later date, one-on-one. Okay, now starting in context and outcomes. So just to put some context around this, and many of you, if not all of you, will be aware of much of what I'm just going to say right now, but just to emphasize that asset transfers really are important to employers who sponsor pension plans. The asset transfer allows those employers to address purchase and sale transactions that occur from time to time with many, if not most, employers. It allows them to carry out any corporate restructurings or organizations that they are going through, and it allows them to combine plans for greater efficiencies, all of which makes pension plans be more easily dealt with by those employers that sponsor them. What you might not have realized, I didn't until we started looking into it, is that there have been literally thousands of asset transfers over the last 30 years. We're sort of estimating somewhere around 3,000. That's a lot. The Ontario PBA was amended around 2010 to significantly change the rules that apply to asset transfers, and that was in response to a court case that occurred in the early 2000s. So since the 2010 change in the legislation, FSCO before us and now FSRA, we've noticed, and I'm sure you have too, that our review times of those applications have often been quite long, and really longer than they need to be or should be, and that gets in the way of all those things, those first 3 bullets above, of having those be carried out. As well, we've heard over and over, and we agree that member communication has become very lengthy, complicated, and really almost incomprehensible to most members. Finally, the transfer rules and the timing of those rules can be difficult to comply with from time to time. So these are the issues that are out there, and leading up to FSRA's launch in 2019, the pension sector identified several areas where they wanted the new regulator, FSRA, to focus on, and asset transfers was one of those three main areas. As a result, we created an advisory committee that met over a few months in 2019 and into 2020, and out of that advisory committee came our new guidance, which was just published in January. So what has changed, or what is, maybe I should have worded that, what is changing, because some of this is still in process? Well, as mentioned, the regulator itself changed. FSCO gave way to FSRA about 1.5 years ago, and you know, while some of our duties remain the same, our approach has changed in some ways subtly, some ways not so subtle, but we really are focusing on being principles-based and outcomes-focused. The guidance, of course, has just been published, and we're going to talk more about that and more about most of what's on this page in our next half hour. But just wanted to sort of summarize it all here. We now have, as a regulator, we have authority to vary the notice requirements that we never used to have. We are encouraging electronic submissions, and in fact, we would rather only receive submissions electronically from now on. It just makes things a lot easier, and I think going forward, it'll definitely be the way to go. Our review process, again, which we'll talk about in more detail, is intended to be more streamlined, to focus our efforts where they mean the most, the areas where there is some risk or uncertainty. We're relying on a new thing, these new certifications that we're asking the plan administrator and actuary to sign when they file a transfer application with us. And we're also changing the people here at FSRA who review these transfers. It used to be all of our staff, and now we're focusing it on a small group of staff. Again, more about that later. We are encouraging dialogue, both before you file anything with us and while it's with us as well. Many of these things won't be that complicated, and you may not need to talk to us, but if there's ever any questions, we want you to come to us and have that discussion. And finally, we're committing to service standards, which we'll go over a little later as well. Or actually, the final thing is that we are also trying to harmonize our approach to the different types of transfers wherever we can. So this slide, I'm just going to talk about really briefly. The top of it, we mentioned here what our primary objects are under the FSRA Act, not the PBA, but the FSRA Act. And that is to promote good plan administration and to protect and safeguard beneficiary rights and benefits. So that's always in the back of our mind, no matter what we're working on and for whatever our guidance that we're developing or our processes is. And the same below, below there is sort of a paraphrasing of our pension sector principles at FSRA. And again, everything that's on that slide is what we think about when we're trying to develop how we're going to approach a regulatory issue. So desired outcomes. Out of all this effort, we are hoping to achieve a bunch of things. And number one is to protect beneficiaries' entitlements. We also want to enable beneficiaries to be informed and to understand what's happening to their pension plan when there is an asset transfer that involves them. We want to allow for members' benefits to be consolidated, which is often an outcome of an asset transfer. Rather than having members' benefits be split into two plans, it allows them to be in one place. We also want to support the sustainability of the original plan and the successor plans and their ability to deliver pensions over the long term. That's really what it's all about. For sponsors and administrators, some of the desired outcomes are quite similar, although it's focused a little differently maybe. Really, we want to facilitate pension plan management for plan sponsors and administrators. They have to deal with corporate transactions and things like that that affect their pension plans, and this is to allow them to do it more efficiently. So we want to streamline the application review process and focus on key aspects that really matter. We also want to help administrators simplify and improve their member communications. We want to clearly communicate our expectations of the pension industry, of the applicants. And finally, where we can, we want to harmonize our regulatory approach under the different asset transfer sections. All right, so at this point, I'm going to hand it over to Tim and he'll go over our application process.
Thanks so much, Mark. I hope everybody can hear me. I think I've said that statement so many times in the last year, but I'll assume everybody can hear me. It's nice to meet you all virtually. I'm going to be going through the application process. The application preparation process is primarily in the hands of course, the plan administrators and their service providers. It can be a significant amount of effort, and we encourage applicants to contact us to discuss any possible hurdles and challenges and propose how they intend to overcome them. I think Mark mentioned this, and we will be really belaboring this point in this presentation. We are trying to be more collaborative. We think that this will allow us to try to proactively address any issues before our review. And as the name suggests, our process aims to guide the applicant to really help them ensure that they're taking the right steps to ensure compliance with the PBA, and of course, ultimately ensure protection of member beneficiaries whose assets are transferring. So under the PBA, there are three main types of asset transfers contemplated. There's Section 80 transfers, which deal when an employer, due to a sale or assignment, basically transfers their assets because of the sale or assignment of a part or all of an employer's business. Whereas Section 81 is really a transfer of assets between plans that has the same or related employer. So Section 80 and 81 are contemplated under Ontario Regulation 310.13 that gives all the specific rules and requirements for how those must be done. And then the third type of asset transfer are Section 80.4 transfers under Ontario Regulation 311.15, and that deals very specifically with the conversion and transfer of assets from a single employer pension plan to a jointly sponsored pension plan. So here are the 6 major steps and deliverables in the application process. Although we don't have time to necessarily go through all the detailed rules and requirements for each of these steps in today's presentation, this portion of our presentation will focus on the key aspects of each of these steps and also provide insight into some of the common issues we've seen in the past. Our hope is that we'll be able to then better position applicants to make a complete and compliant application by pointing out some possible hurdles that you want to avoid. But ultimately, we do want to work together in advance of an application submission in order to then be able to hopefully streamline our review with the hope that we will uncover then fewer possible issues and be able to expedite our review process. So for the first step, the preparation, as I said before, we do really encourage applicants to engage with us early if you have a more large or complex application. So allow us to try to proactively address any issues before the application is filed. Furthermore, it's important that you address any unresolved regulatory issues that may impact the asset transfer and any of the plans involved. So if there's more than one original plan and the successor plan, if there's an outstanding regulatory issue with us that could affect the asset transfer, that really needs to be dealt with first. Otherwise, it could delay our review of the asset transfer application. The application, of course, must include any agreements like purchase and sale agreements, for example, and consents required under the PBA or regs. Lastly, if your plan has a letter of credit or an LOC, those transfer amounts must reflect any of those LOCs, and the implications must be determined since those LOCs are unique to a specified legal entity, and they could trigger a funding requirement under the asset transfer. Now, asset transfers between plans that have the same sponsor or legal entity might be able to amend and transfer an existing LOC to the receiving plan where the issuer or trustee agree. Some common issues that we see with this part of the process is failing to address pre-existing regulatory issues, which I already talked about, and incomplete applications. We do really encourage that applications are filed in totality, complete with us at one time. Certainly that would avoid us having to go back and forth trying to get more information in order to be able to complete our review. Notices. Notices are a very, very important step, one that we take obviously very seriously, because ultimately it's the notices that ensure that the affected people and members are informed about the transaction, their rights, and how their benefits will be affected. The notice content and timing are prescribed under the PBA and regs. I'm not going to go into them in detail right now. We don't really have time during this webinar, but certainly information is there. If you have any questions, you can contact us. We do encourage that the notices be straightforward and understandable. And we know this is a little bit counterintuitive since the regulations are quite detailed as to what has to be into a notice. I think there's over 50 things now that have to be in notices. But that said, that doesn't mean that they can't be written in a more straightforward manner. And in fact, we encourage, for example, having kind of a key information upfront page 1 for notices that lay out the key information to members, and then you can get into more of the details later on in the notice. As Mark mentioned, applicants can now request FSRA to vary or waive notice requirements, and we will be discussing that a bit more in the review process section after this section. So some common issues we've seen, of course, that the notice doesn't contain all the prescribed requirements. Things like omissions of contribution rates, benefit formulas, early retirement provisions, etc. Notices are complicated and lengthy. Yes, we understand why they're lengthy. That's because of the regulations, but that doesn't mean they have to be overly complex, and they can be written in a more plain language, simplistic manner to make them more understandable. And that's something we really encourage. Member notices sometimes are not issued in the prescribed time. And also, there's been many situations we've seen where unions were not provided the notice. And it's our position that all unions in the original plan or plans and the successor plan, whether they have members involved in the asset transfer or not, should be notified of the asset transfer. Amendments are also an important step in the application, the asset transfer application process. Certainly, the applicant must file a signed and adopted plan amendment for the asset transfer along with the completed FSRA Form 1.1. Just a note about the Form 1.1s, we are going to be revising and posting that new Form 1.1 electronically later this year, and that will be required to be filled out and filed electronically. If the amendments are filed separate from the application, which we understand happens sometimes, we do ask that the application, when filed, should note this. As many businesses have, we've been working from home primarily over the last year. Hopefully that's not going to last forever, but certainly it helps us a great deal with our move to a digital platform where you advise us if something has been filed kind of in a piecemeal fashion so that the reviewer is aware of that. So amendments to cease benefit accruals in the original plan are adverse amendments under the PBA. So these amendments must be filed prior to their effective date, and the applicants must ensure that the notice requirements are complied with. Now, amendments to cease accruals are needed unless the accruals in the original plan will cease by operation of law, meaning like a change of employer, or via existing plan provisions. It should be noted that notice of plan amendments follows actually the rules of the major authority. So what I mean by this is that for asset transfers that have multi-jurisdictional pension plan members, members who are not just under Ontario jurisdiction, the notice requirements will follow actually our authority if we're the regulator overseeing the plan. So the adverse amendment notification rules should follow Ontario rules in that situation. So some common issues that we've seen with amendments is that the original plan has not been amended to cease accruals, although that can maybe, I guess, not be a requirement, as I noted before with regards to a change of employer. But certainly an amendment is still needed for the asset transfer, whether the amendment is needed for ceasing accruals or not. Sometimes amendments are not signed or they're not filed with the Form 1.1. And lastly, plan amendments prior to and actually unrelated to the transfer were not filed prior to the asset transfer application. Now, this can be a problem because we really do need a complete plan documentation history in order to complete our review. So if we notice in our review that there's some reference to an amendment to the plan that was made previous to the asset transfer, but we don't have it on file, then we have to go chasing after that, which can cause a delay. Actuarial reports, as you know, this is a major piece of the asset transfer application. It's the main financial report for the asset transfer application and therefore extremely important. We spend a lot of time reviewing this report in our internal review. For Section 80 and 81 transfers, it's important to demonstrate compliance with the solvency ratio test. And by that I mean specifically the 5% rule, whereby the solvency ratio of the successor plan cannot decrease by more than 5% from what it was before the transfer. And secondly, the successor plan solvency ratio after the transfer can't drop more than 5% below the solvency ratio of the original plan or plans prior to the transfer. So these tests must be met only if the solvency ratio of the successor plan after the transfer is below 85% for a Section 80 transfer or below 100% for a Section 81 transfer. And I know that's quite a mouthful, but I'm sure that your actuarial provider, if you're obviously working with one for this application, will be able to guide you through that as well. Now, funding of each plan continues on a pre-transfer basis until the assets are transferred. Not the consent given, but the assets actually being transferred. Of course, the actuarial assumptions and methods for solvency valuations, they need to be consistent for the original and successor plans. And if the transferred benefits aren't replicated in the successor plan, then the commuted value test has to be met in that a comparison is performed on the total pension benefits for each member. And we do ask that if that's happening, that you please provide us a sample calculation with the application. Some common issues that we've seen with asset transfer actuarial reports are that the assets are not correctly allocated for partial transfers in multi-jurisdictional applications. I think Mark will talk about that a bit more later, but that's a bit of a complex situation with regards to the multi-jurisdictional pension plan rules. And valuations are sometimes not prepared as of the effective date of the transfer, or if they might potentially use projections as opposed to real data. Certifications. As Mark mentioned, this is a new step or a new documentation step that we have in the process that came out of the Technical Advisory Committee and our new guidance. And we certainly encourage the use of these certifications, although it's not mandatory. But if you use them, we expect that our review times will be more streamlined and efficient and quicker. So the information disclosure is really a helpful tool, not just for us, but also for applicants, because it can really guide you through what is required. There's two main pieces in the information disclosure. There's the application summary, which is certified by each plan administrator, and the actuary certification, which is signed by each plan actuary. Information disclosure should be completed for each original plan and the successor plan. You know, it's important that these be filed. We do encourage them. We will rely on these, as Mark said, to streamline our review process and use more of a risk-based approach to identify and review the aspects of the applications that ensure member protection. Of note is that if the application that has both DB and DC assets in it, the application can identify both the DB and DC components, or the DC assets can be dealt with in a separate filing. Both the application summary and the actuary's certification can be signed in counterpart. And one thing to note with multi-jurisdictional asset transfers that have Quebec members is that it's important to note that Quebec has a provision that requires that the surplus entitlement language in the receiving plan be at least as favorable to members as in the original plan. So that's something very important to keep in mind for any Quebec members. Some possible issues that we might have with these certifications, we don't really have a history of issues right now because this is a new part of the process, is that other jurisdictions' legislations might not be fully considered. As you're all probably aware, under the multi-jurisdictional pension plan agreement, as the regulator that oversees the plan, we have to ensure that other jurisdictions' legislation are complied with for any members that are governed by that legislation. So we expect that the application for multi-jurisdictional pension plan asset transfers will fully consider those. And lastly, certifications might not be submitted at all, which is really your choice, but we certainly encourage that they do be filed. Or if they are filed, they might not be fully completed. So if you're using them, please, we do ask that you fill out every section of those certifications. And finally, after all that work, it's time to submit the application to FSRA for us to do our review work. Just a few things of note here. Applicants can request filing extensions of 60 days if there's reasonable grounds, or over 60 days if there's extraordinary grounds. Filing extensions, you know, they can be made after the due date, but we certainly prefer that they be made before the due date. And we ask that you file your applications electronically, as Mark mentioned before, either by email, or if the documents are too large for an email, you can use FSRA's secure file transfer protocol. Please just get in contact with your pension officer and they will provide you a link to use that. We really don't need hard copies. We prefer electronic copies and don't need hard copies to be sent afterwards. Some common issues that we've seen with submission is that applicants request filing extensions after the original due date. That's not necessarily not in compliance, but we certainly prefer it before the due date. And sometimes applications are filed piecemeal. I mentioned this before. It can delay our review times if we're having to chase after certain documentation, or if you know, if there's certain pieces that were filed way in advance, but maybe the application didn't reference them. So it's important. We prefer that everything be filed at once, but we understand that in certain situations, for example, amendments might come in a bit earlier. So now I'm going to turn it back over to Mark, who's going to give you some insight into our review process.
All right, thank you, Tim. So, as you all know, the PBA requires FSRA's consent in order to proceed with an asset transfer under these sections. And the PBA prescribes a number of requirements that have to be fulfilled in order to get that consent. And so our role is really to determine if the PBA and regulations have been complied with. And so one of the big changes we're doing now, starting this year, is to commit to a service standard of 150 days. So that's something that we're working our way towards right now. And if you've been involved in asset transfers in the past, you would know that in many cases they took a year. Sometimes they've taken 2 or 3 years, which is just not really workable. So our goal is 150 days. The part of that process that we're starting now is that when a new application comes in, we're going to have an initial sort of 10-day period where we look at it to see what's there, that all the major components are there, you know, the actuarial evaluations, the plan amendment, copy of notice, and so on. So that's just an upfront high-level review so that our staff can get back to you after about 10 days and let you know if it looks like something's missing. And it may be that something isn't missing and we've just not read it right, but it gives you the opportunity to tell us that or to tell us when that missing piece will be filed. It also allows our staff to tell you who they are and like who the person is who's doing the review. So you'll have a contact for that. We're going to ask of you if we ever need information or documents that are missing. We're going to ask you if you can reply in 30 days. You can see that, like in the past, again, sometimes we've had replies come in 6 months, 9 months after we've asked for something. So if that happens, we obviously can't meet our 150-day goal of completing our review. We're also committing to work with you during this whole process of an asset transfer to the extent it's needed. It won't always be needed, but if you have issues or questions or there's something that's not understood what is needed, contact the officer for your file and we will work with you to help you come to an answer to your question or a resolution to the issue. Now, our normal approach going forward is this sort of streamlined review process where we're focusing on certain things, not every single thing. However, we can change that for any given asset transfer if we thought it was appropriate. So just depending on the nature of the transfer, the number of plans, the complexity, you know, maybe something's a brand new type of situation, hasn't been seen before, we may want to take a deeper dive into that application, and we will if we think that. Our detailed review, if we do take that more deeper dive into the application, may focus on communications if we thought there was an issue around members understanding what was happening. It may focus on changes to members' benefits if accrued benefits in the past are being altered, which is permissible, but we have to ensure that the value of those benefits is maintained. We may look at the consents that are given, especially if you know, maybe the number of consents is right on the edge of meeting the necessary percentage. That's in section 80.4 transactions. And we may consider the financial position of the plans and the sustainability of the plan sponsor. So these are all things that we could look at in more detail than our normal process would speak to. And as well, from time to time, we're going to spot check certain things. So if there's an aspect of member communication that we are not typically going to review every word on every time, we might, though, spot check that to see that it is being addressed properly from time to time. And finally, if we are doing a more detailed review of any aspect of the transaction, in most cases, it won't affect our timelines. We're still going to aim to complete our review in the 150 days. But in those cases where it does affect the timeline, we'll let the applicant know that. So protecting members is really the key to all of this. And most of the protections are really built into the legislation for defined benefit transfers. First of all, there's a requirement that there's essentially a pro rata transfer of assets, including any surplus if there was surplus. So that means that the members who are leaving a plan are moving over with the same ratio of assets that they had in the plan they're coming from. There's also the 5% rule tests that Tim mentioned. I won't go into those in detail, but there's several of them, depending if it's a Section 80 transfer or 81, there's slightly different tests. But again, those are there to protect members so that the plans that they're moving into are funded in a certain way. And then finally, there's the cumulative value test, which we've mentioned, which is simply that the cumulative value in the receiving plan for any given member has to be at least as great as it was in the transferring plan the day before it left. The other big piece is communication, making sure that the member is informed and understands that they can contact FSRA if they have concerns about the transfer that they're affected by. So notices must be given to members and unions within certain prescribed timeframes. They have to contain certain information, and hopefully that's written in a way it's more easily understandable. The notice must contain our contact information to advise them that they can contact us with any concerns about the application. Finally, the notice that goes out to members and the benefit calculation rules of the applicable jurisdiction are going to apply for those members who are not Ontario members. So this slide is just sort of depicting our new team approach to looking at asset transfers. The old approach was any transfer that came in was reviewed initially by the officer or analyst whose plan that was, each officer and analyst was allocated a set of plans, and if it occurred in their plan, they would be the ones reviewing it, which meant that all of our officers and analysts would, from time to time, review asset transfers, along with dozens of other things. So their focus wasn't on transfers, and that's what we're trying to change here, is to have a dedicated team of a handful of officers, analysts, and technical consultants that will look at every one of the transfers coming in. As a result, they already are, and they will be even more knowledgeable about asset transfers and about the issues that can arise and so on. And we think that's going to make a really noticeable difference, and that's one of the big reasons why we're going to be able to meet our 150-day standard. So a couple slides here just on special considerations, variants of the notice and timing content. We now have authority under the Act to allow for variations or waive certain requirements. And we're asking you to let us know if you want us to waive a requirement. Our guidance mentions some of the maybe more typical requests that we expect to see, but it by no means is meant to be exhaustive, and you can come to us with anything. Doesn't mean we necessarily agree, but for sure come to us and let us know what you're thinking, and we can talk that through. Because in many cases, the requirements that are set out in the regulations may not all of them anyways, be applicable or understandable in the context of a given pension plan. As well, when you file the application with us, you should note in there if you have taken advantage of that waiver or variance. And so I've listed here a few of those more common things, which is things like a lot of the requirements for the notice really are similar, and in some cases identical, to the information that's required to be in the member's annual statement. So instead of repeating all the information that was in the statement that might have just been given to the members in the last few months, you can reference the annual statement and not repeat it all in the asset transfer notice. So that would be an example of where you can make the notice be not so lengthy, be more understandable, and hopefully easier to produce. Similarly, for the employee booklet, you might want to refer members. Maybe there's an online booklet, and again, instead of repeating all that information that's in the booklet, just refer them to the online booklet. We can give timing extensions for the notice if there's some need for that as well. And from time to time, we will notice certain things that maybe that aren't quite compliant to a T, but which have no meaning and no effect on anything. And so we can simply accept those as being not material to anything. The second special consideration, multi-jurisdictional plans and asset transfers. First of all, if you have a multi-jurisdictional plan, so a plan with members in more than one province and or federal members, and there's a transfer going on, then the transfer application gets filed with the regulator where the original plan is registered. And that'll be registered wherever the plurality of members is. And that regulator then essentially applies the legislation of all the other jurisdictions that are applicable for that plan. So only the benefits and the benefits accrued in Ontario by members subject to Ontario's PBA, only those have to follow the Ontario PBA rules and transfer regulations. If you have, for example, Alberta members in that same transfer group, they're going to be subject to the Alberta rules. Quebec members subject to Quebec rules. And that's important to keep in mind, because although Ontario's rules usually are if you comply with Ontario's, in many cases you're complying with most of the other jurisdictions. There's often some outliers there, Quebec being one where they have a specific requirement around surplus provisions. So the applicant has to be aware of all that and ensure that they're complying with whatever jurisdictions are relevant. A second sort of complicated thing with these plans is if you're dealing with a partial asset transfer where some of the assets are coming from a multi-jurisdictional plan and moving to another plan, then there's an agreement that was a revised agreement was signed last summer for multi-jurisdictional pension plans as part of the CAPSA initiative around that. And that agreement basically spells out how the assets get allocated. First, they get allocated by province, and then they get allocated by the members who are transferring out of the plan. It is complicated, and it has to be adhered to. So if we're dealing with such a transfer, we will look for the actuarial report to identify that allocation of assets process. One final sort of special case is if you're dealing with a Section 80.4 transfer, which is generally a single employer plan transferring into an Ontario jointly sponsored pension plan. In those situations, we ask that you ensure that if there's members that are moving over to the JSPP, we ask that you ensure that the other regulators are on side with such a transfer. The reason being that the Ontario JSPP, Jointly Sponsored Pension Plan, is unique to Ontario, and it has certain features that some other provinces may not be aware of and or may not appreciate or want their members going into those plans. So we want you to look into that before we go through all this. Otherwise, we will have to do that at the back end, and that could delay things. Okay, that's it for this segment. Back to Tim, and he's going to talk to you about our decision-making process.
Thanks, Mark. And yes, so it's time to talk about the finish line where we all want to get to. So generally, when an asset transfer is applications compliant, there's no reasons to withhold it, FSRA will give its consent. And generally, we do that consent through a letter addressed to the applicants. Now, this is something that we've done for years with Section 80 and 81 transfers using a letter consent process. For the past few years for Section 80.4 transfers, we were using a notice of intended decision, a NOID, for a while, but the decision has now been made to make that a consistent process across all asset transfer applications. And we now do a letter of consent for Section 80.4 transfers as well. That said, there are situations where we may issue our consent using a notice of intended decision, and then ultimately followed by an order. In those situations, we will advise applicants that we're going to use that process. And where we might use, or where we must actually use that process, is if there are any terms and conditions attached to our consent, which is rare, or even more rare if we're going to refuse to consent to the transfer. Now, certainly, FSRA, we will provide you ample opportunity to address any issues in the application prior to coming to that decision. But ultimately, if it doesn't meet the requirements, then we do have to refuse the application, and we will do that as in the process of a NOID to refuse. Similarly, well, not similarly, there is another opportunity whereby if we advise the applicant that we are going to move to a NOID to refuse, the applicant could also withdraw their application. So when we do use a NOID, there is a process that comes out of that. First of all, when we issue a NOID, we ask that the administrator of all the plans involved post that NOID electronically so that members can easily access it. Now, if electronic posting is not possible, administrators should contact us to discuss alternate options. Applicants can discuss any issues that they might have with posting with us here at FSRA. Then when the NOID is issued, there's a 30-day period where the impacted people or entities may request a hearing before the Financial Services Tribunal, the FST. If no request is made within 30 days, then FSRA will be in a position to issue a final order to either consent or refuse. But if a hearing request is made within those 30 days, then no final order in respect to the NOID can be issued until a final decision is made by the FST or any court hearing if an appeal is made to the FST decision. There are still a few important steps that occur after consent is given to an asset transfer. Until substantially all of the assets have been transferred to the successor plan, all the plans involved in the asset transfer, if there's more than one original plan and the successor plan, they have to continue to operate as separate plans, and the liabilities of each of those plans still remains a responsibility of that plan, and they still remain responsible for things like plan funding, benefit payments, and submission of required filings to FSRA. Now, substantially, you might be asking, what does that mean substantially? Well, we do note that in the past, in certain situations, the transferring plan might leave behind, for example, a small amount to cover off benefit payments or maybe expenses for a month or two. Or there could also be a situation where there's a problem with one asset, possibly a liquidity issue with that asset that they can't deal with immediately. And in those situations, we would still consider that the asset transfer has substantially occurred and therefore is completed. So for a full asset transfer for filings, if the actual transfer of substantially all the assets has not occurred by the end of the transferring plan's fiscal year end, all filings, fees, and assessments are required for that completed fiscal year. So let me give an example because this is a point of confusion quite often that we get questions on. So let's say that the original plan has a fiscal year end of December 31st, and there's an asset transfer application made. Everything goes well. FSRA provides its consent, and we issue that on November 23rd of 2021. But the actual assets were not transferred until March 14th of the following year, 2022. In that case, all filings, fees, and assessments for the 2021 fiscal year are generally required by the applicable 2022 deadlines. Now, for the stub year, which is Jan 1, 2022 to March 14th, 2022, our position is that those stub filings are not required, and that includes for the partial PBGF assessment for that period of time. So now I'll just turn it back over to Mark with a few closing remarks, and then we'll open up for some questions and answers.
Excellent. Thank you, Tim. So we got one more slide to come up here. Basically, I just want to emphasize that the changes that we've been talking about are happening. Some of them have happened, others are continuing to happen, and our review process is undergoing those changes as we speak. We did have a backlog. We've worked our way through most of that, and new applications that are coming in are going through our new process now. One thing that we obviously have not addressed in this webinar is DC, defined contribution asset transfers. Just want to say it's not that we've forgotten about them or don't care about them. They are important. We have, in fact, probably as many DC transfers as we do DB. But DC, of course, is or should be much simpler. You don't have the actuarial issues, the benefit issues, and so on. What we're developing for DC is an online application tool that so the applicant would go online, submit or answer questions that are asked, submit documents like a plan amendment or a copy of a notice, and the entire review process will likely then be collapsed into a space of maybe just a week or a couple of weeks. So we think this is going to really be excellent for DC transfers. We do have problems with DC transfers, surprisingly. Usually it's around a lack of documentation, failure to do some of the basic things that the PBA requires, like give notice to members. So this portal application will immediately tell the applicant that they've got a problem if, for instance, it says, please attach a copy of the notice, and there was no notice. So they'll know that they have a problem to deal with right away. So that's coming hopefully later this year. As well, either later this year or next year, we're hoping to have an online application tool for DB asset transfers as well. It won't be as automated. There's just too many things that can go on with a DB transfer, but it'll just make the whole process of submitting an application easier. So that's it for our prepared words. We do have some Q&As, some questions, I should say, set up on the questions list here, which I think everyone can see. So I think what we'll do is go to the top of that list.
Yep. I think the first one came in at 11:03, Mark, which was some pension plan sponsors have denied. Oh, no, but it looks like Julina answered this. So first of all, some of the questions were answered by one of our technical consultants here, Julina. Thank you very much for that, Julina. So we're going to pass over the questions that were already answered by Julina and move on to some of the ones that were not answered by Julina. So I guess one came in, Mark, at 11:14. I would like to know how many pension plans you regulate in the private sector.
Right. I don't have the actual numbers, but I give you sort of ballpark, and I think there's a second question after that. I'll do them both together. I think we have somewhere around 1,400 defined benefit plans and somewhere around 3,000 defined contribution plans. Those numbers won't be quite right, but it gives you an idea. And then the second question, I assume from the same person, said that all they see is that the numbers of plans are dropping and the regulatory environment increasing. What's the deal? Why are we making this so difficult? So all good observations. I have the same observations myself. I've been in this industry for 30 years, and there's nothing to argue with there. But what I would say is that we're not making this difficult. In fact, we're trying to make it more workable, and that's the goal of a lot of our changes, is to ensure protection of benefits, but take away some of the time and the effort needed in the past to make these transfers work. I'd also point out, we're the regulator. We're not the government. We can't change the PBA ourselves. So we take the legislation as given to us.
Great, thanks, Mark. Looks like Julina did a great job in answering a lot of the other questions after that. Just to let everybody know, yes, there will be a recorded version of the webinar included in our next pension e-blast, so that will be available for everybody to see. I'm just scrolling down here. Okay, here's one that Julina didn't get to. Does one have to assume the plan is closed for the going concern valuation for PFAD on a Section 80 transfer?
Sorry, I'm just trying to find that question. Oh, there it is.
At 11:35.
Yeah. Plan is closed for the going concern valuation for PFAD. I don't have an easy answer for you there. That must be coming from an actuary. And if you want to contact Tim or I after this, send us an email and we'll look at that. I haven't really been thinking about PFAD stuff for the last year and a half, so I can't recall now what my answer to that should be. But if you give us an email, we'll get back to you about that.
Follow-up question to that, where the effective asset transfer date aligns with the last member statement date, is it sufficient to point the members to that statement if already provided rather than attaching the statement to the notice?
Yes, it is. So that would be one of those variations you could ask for, because right now the regulations say you have to put all this stuff into the notice. And so if you would rather not do that and instead point to the fact that they just, they got a member statement so many months ago, and of course, if a member can't find that statement, I mean, they have to be able to ask for it to be given to them again. But yes, you can point to the statement. You don't have to actually attach the statement, although you could do that too. Either would work. Well,
sorry,
can
Mark.
you please explain the rationale? Oh, I think we had, yeah, okay, that was answered as well. Where's one that hasn't been answered?
Julina did a great job.
Can you confirm whether FSRA, oh no, oh, that one wasn't answered, I don't think. The question from Christina, at various times in the webinar has been noted that FSRA only wants to receive items electronically. Given these statements made, can you confirm whether FSRA will be issuing a formal statement about this for our records? If by that you mean, will we be telling everyone that that's the case, then yes. We've done so on a couple occasions, and we'll do it again in e-blast, asking people to submit everything electronically, and that there's no need for a hard copy. Or maybe you're asking whether we would be acknowledging receipt, like a formal acknowledgement of your filing, and that we will be doing that as well. So hopefully that answers that question.
Yeah. So the next one was answered by Julina. There's a question here, I'm not completely sure what it's about, but will you have someone reach out to me with the statistical data I requested?
That might be the number of plans data.
Oh, I see.
If what I said isn't detailed enough or accurate enough, again, just contact one of us and we can get you much better numbers on all of that.
Yep. There's a question here about transferring IPPs to a LIF.
Oh yeah, so that's okay. So IPPs, individual pension plan with one, sometimes two members are in them, even though it's called individual. This is not what we're talking about today. Is what I would call, for lack of a better word, a group or a bulk transfer, and it's where the employer is initiating this, not where the member is. What you're asking about, though, is also a different section of the Act, where an individual wants to move the value of their benefit out to a LIF. And like all pension plans that we regulate, plan members have that option when they terminate employment. So it's tied to employment and is set out under the Act. So an IPP member who terminates employment will have transfer options, individual transfer options, one of which would be to transfer it into a LIF if they're at the right age for a LIF. So I hope that answers that one. As well, I'll just mention, because we're talking about IPPs, there has been a recent change just a couple months ago that anyone who has an IPP, if they are a significant shareholder, they can essentially apply to have their IPP exempt from the PBA entirely. So that's another way around things. Throw that out to you, and you could take a look at that as well.
Great, thanks, Mark. I noticed that we're at full time, but as Mark said at the beginning, we're willing to stay on for a little bit longer to try and get through these questions. So if you're willing to stay with us, then we'll do our best to get through them. So Mark, there's another question here. In some asset transfers, the number of transferring members is relatively small by comparison to the number of unaffected members. In these cases, we recommend the use of extrapolated membership data from the most recent valuation report. This is more efficient and can significantly lower actuarial fees and has no material impact on member benefit security. We note that OSFI routinely permits this approach. Can FSRA provide some explanation as to why they would think this is not appropriate from earlier comment?
Yeah, okay. Good question. First of all, I'd say that the vast majority of our asset transfers, so we get like 100 of these a year, maybe 50 that are DB. The majority of them are not immaterial transfers. Like they are something, 10%, 50% of the plan. Like, so they do have an impact. But you're right, there are some, especially when we're talking about transfers into large government pension plans, where the amount coming in is very tiny compared to the huge plan it's going into. So I would say if you're dealing with a situation like that, then talk to us, because there may be a way to deal with that makes more sense. So our comments, we have to address all the transfers that we see, and for most of the transfers we see, our comments are applicable, but there may be cases where a different approach is appropriate, and so we just ask you to talk to us about that.
Great, thanks. Question here, is a printable copy of the presentation available? I mean, we are going to be posting a recording of this webinar. Let us take that away as to whether we will make maybe a printable PDF version of the presentation available as well. But we'll definitely take that into consideration. Is the member notice due 60 days or 6 months after the effective date?
Oh, I think that one was answered earlier. It's six months.
Yep. Yeah, that's right. Okay, and then looks like Julina answered this one. One more question, Mark. In addition to circulating the link to the webinar, can you also circulate the deck as a separate file? Okay, so yes. That one is similar to what we said before. We will definitely try to do that as well. So I think we got through all the questions, Mark.
I think so. So
yeah.
If you have other questions, send us an email. And yeah, this has been great. Thank you again for attending.
Yep. Thank you very much for the interest and for your time. and enjoy the rest of this beautiful sunny day.
Bye-bye.
Bye for now.